Andrew Feldman representing healthcare providers and healthcare sales and marketing professionals nationwide. Today, I want to jump right into the anti-kickback statute and what the courts say about when, if ever, you could prosecute a sales and marketing professional for receiving or paying kickbacks. Remember, the anti-kickback statute of the AKS makes it a crime to willfully pay or receive any remuneration in return for inducing referrals of healthcare services or items reimbursable under a federal healthcare program like Medicare, Medicaid, or TRICARE. Let's start with United States versus Marchetti and United States versus D'Onofrio, two Fifth Circuit decisions that deal with the same underlying facts and how they address this issue. Marchetti and D'Onofrio were both defendants in a trial which involved a genetics lab specializing in PGX tests that can save lives and prevent deaths. It was a startup lab, and the CEO was a brilliant scientist, but quite frankly, he was also a terrible financial manager and an overall morally bankrupt person. The lab, the morally bankrupt person's lab, needed sales and marketers with experience in the industry, which makes sense because unless you have experience in the industry, doctors are going to be reluctant to listen to you about anything, about whatever product you're selling, whatever product you're trying to educate them about. So, the lab entered into contracts with these experienced sales and marketing professionals and sales groups. One was Marchetti's sales group and another one was D'Onofrio's sales groups. And those groups were composed of more marketers who would educate providers, doctors, about PGX tests and how they save patients' lives and why it helps doctors manage medication and possible adverse reactions to medication. And the doctor who ordered the test and the patient who received the test signed a lab requisition order, kind of like a prescription, authorizing the lab to run that test for that lab. At the core of the case were the contracts, the sales and marketing contracts between the lab and these sales and marketing groups. Under the first contract, as contract one, between the lab and the sales and marketing groups, the lab paid both D'Onofrio's group and Marchetti's group a percentage of collections derived from Medicare and commercial insurers. So in other words, if the lab got paid $100,000 this month and it was 30%, that's what the marketing group would get. 30% of $100,000 is $30,000. Later on, the lab hired some big law firm who told them about some advisory opinions from the Office of Inspector General, Department of Human and Health Services, or OIG-HHS, which raised concerns about percentage-based compensation and how it was, quote, problematic because it technically violated the anti-kickback statute. Now, how could this be? Because you're paying marketers remuneration, anything of value, to, wait for this, arrange for or recommend ordering or purchasing tests. Let that sit in for a second. Back to this later. So the lab took some of that advice and also took a contract from another lab and used it to create what we call contract number 2, the activity-based compensation contract, or ABC contract. That contract got rid of the percentage-based compensation, and the sales reps were now paid based on their activities. And they're paid $3,000 for each sales rep that was an active rep, meaning that they performed certain activities like marketing or education. This created a problem because guess what? This is going to be a big surprise. The last thing that sales reps want to do is fill out more ridiculous, monotonous paperwork about what they did that day. Who wants to do that? And so what the lab and the sales groups did was they violated the new contract. They said, okay, how do we get to paying these reps the old percentage, but under the new contract? So what they did was the lab would ask the sales groups to provide a specific number of active sales reps, so that number added up to the old percentage. So if they needed 100,000, you would do 100,000 divided by 3,000. That's how many active reps you would need, right? So they did that, and that was technically for the lab against the big firm lawyers' advice, because they said the percentage was problematic. This process, by the way, of backing into the old contract using the activities to back into the percentage was called matching. Anyway, both Marchetti and D'Onofrio appealed their convictions, saying this is not a violation of the anti-kickback statute because regardless of what we did with these contracts, whether we created a structure this way or violated this contract, all we're doing is marketing and advertising. So let's start with Marchetti. The Fifth Circuit agreed. First, it said, the structure of the contract alone is not sufficient evidence to produce a conviction under the anti-kickback statute. Rather, the government must have produced something more. In particular, it needed to prove that the lab and Marchetti, the sales rep, intended to, quote, improperly influence those who make healthcare decisions on behalf of the patients. I'm going to say that again. Intended to improperly influence those who make healthcare decisions on behalf of patients. And that is where the government dropped the ball. That's what the Fifth Circuit said. That's language that they used. Even more importantly, it said that because the Fifth Circuit in a prior decision leaves room for permissible advertising, the AKS provisions supposedly criminalizing recommending or arranging for ordering or purchasing cannot be read so broadly to subsume permissible advertising. And then it concluded that the government still needs to prove something about exercising undue influence on patient selection of services. Last but certainly not least, the Fifth Circuit emphasized in Marchetti that the interaction with the relevant decision maker, the person who's deciding where those healthcare services are going to be ordered or provided, has to be a part of the decision in evaluating violations of the anti-kickback statute. Great decision. Going to really hurt future prosecutions for the government, we hope. In D'Onofrio, the Fifth Circuit reached the same conclusion and said that the marketing activities, because they're just marketing activities, were insufficient to sustain a conviction under the anti-kickback statute. And it said, quote, that is to the extent that the lab owner's express intent was to pay D'Onofrio's sales group in return for arranging Medicare business. D'Onofrio was advertising in the eyes of the anti-kickback statute. And that is not changed by the decision to call payments activity-based compensation. Brilliant, wonderful. In other words, arranging for doctors or recommending that doctors order lab tests is nothing more than marketing or advertising in the eyes of the AKS and in the Fifth Circuit, unless you can show that the marketer exerted some type of undue influence. D'Onofrio, of course, also reinforced that there has to be a payment to the relevant decision maker, and there's got to be that interaction with the relevant decision maker. Let's talk just a second about this undue or improper influence, because both decisions emphasize it, and they talk about unduly influencing the selection of healthcare services. What the heck does that mean? It means someone, it could be a marketer, it could be a doctor, that's a bigger problem, but it means someone who is being paid to control who performs the services. So who would that someone be? It could be an insider at a doctor's office, right? You're paying the medical assistant compensation based on her sending prescriptions to a particular pharmacy because she's the insider, she's got access and she's got influence and she's got control over where those prescriptions are going to go. Problem. Same type of problem for recruiters for home health care. They interact with the patient. They have the ability, if paid, to direct where that patient's going to get home health. Basically patient recruitment, right? And then, of course, patient recruiters, a patient advocate for a pharmacy that knows patients with rare conditions, like, say, for example, hemophilia. If you are paying that patient advocate who has direct access to these hemophiliacs, for every time that that hemophiliac patient obtains a prescription at your pharmacy, you got a problem under these decisions, okay? It could also be, and this is where it's much grayer, a sales rep for a certain pharmacy. I'm just using pharmacy as an example. But how can that be? How is that possible? Well, here's how it's possible. If the rep gets the prescription, say it's a blank prescription that doesn't indicate which pharmacy it's going to, and the patient hasn't signed it or said, I agree to have my prescriptions here, then the rep who's getting paid is actually directing, right? They've got some level of influence over where that prescription is going to go, okay? We've covered a lot here. Fifth Circuit decisions in Marchetti and D'Onofrio. Marketing's not a crime under the anti-kickback statute. And we'll talk about how Marchetti and D'Onofrio are great decisions, but also there's another decision out of the Seventh Circuit called Sorensen. We'll talk about that next on AKS Marketing number 3. Andrew Feldman, representing healthcare providers and healthcare sales and marketing professionals nationwide.